very easily, when we put aside our expectations, we can see that this man can very, very well, very likely be acquitted on all counts.
Ike Speaks. What's good with ya? So let's get into it first. The Derek Chauvin trial. I got to make this as dramatic as possible. The Derek Chauvin capital murder, we all seen you do it, homicide, cop killer trial. Yes. Like if I had a TV network, that's how the shit would come on. The Derek Chauvin homicide, cop killer, murderer trial. Because they trying to soften. They do such a job on these networks of trying to soften and then just vilify George Floyd like
they called it the George Floyd trial.
Yeah.
What?
So week 3. So let's slow walk it. Week 3, because there's a couple parts to it that I don't understand.
Okay.
Week 3 of jury selection.
Yes.
We saw there was some talk last week. They were like, man, it's gonna be hard finding someone that hasn't seen the tape. And they're even talking about maybe they have to move it.
Right.
And then OJ gets on Twitter and be like, "Nah, they ain't moved mine, so they have to move it."
And they're not moving his either.
Yeah. How realistic of a request was that? Was it even considered?
Yeah, it's a realistic request given the media coverage, right? It's a realistic request, but it's not likely because it was so highly covered. No matter where you go, you're going to be met with the same type of people who have probably seen the video. So the question doesn't become whether or not you saw the video. The question is whether, having seen the video, can you still be fair and impartial in this trial? And many people said, yeah. Some people hadn't seen the video, only saw still images here and there. Some people said they saw the video and they could still be fair and impartial. And some people straight up and said, I cannot be fair and impartial. They actually had a seated juror that once it was released that the city had settled for $27 million. He's like, oh, I can't be fair no more. I can't be fair anymore. And they had to replace him. So they're finished basically jury selection. They have 12 jurors and 2 alternates. They're looking for at least 2 more. The judge would like to have 4 alternates as a safety net, just in case some shit goes south and they have to replace jurors. But opening statements Monday, the 29th.
Now, a couple questions, and Mr. Clarkson has a question that was in my head, and I was just about to ask it. Like, as a prosecutor who's gone through this process, do you believe when people say, "Oh yeah, I can be fair and impartial"? What type of person is that? Like, what type of person do you have to be to really lay that out there and be like, right. Are you a trained Navy SEAL? Are you an emotionless vessel? Like, how does that? What do you mean I can be fair and impartial?
It means that I can listen to the evidence without pre-forming any judgment about this case. I can keep an open mind, and I can receive the evidence that is going to come in, and then I can pair that evidence with the court's instruction on the law, right? Because the court is going to say, this is what the law says about 3rd-degree murder, 2nd-degree murder, and 2nd-degree manslaughter. The jury then has to take those facts and see if they satisfy the elements of those crimes. So it's not that difficult. If you can do that and keep an open mind and not be swayed just by that video alone, then you would be able to be a fair juror.
Now, for the person that says after the civil, verdict or whatever, or payout, they can no longer, what do they mean? They're swayed which way?
They're they're so influenced by the fact that the city paid the family that much money. It's sort of them acknowledging guilt.
Oh, okay, got it. So it'd have been that way. Okay.
Yeah.
I thought they would have been the other way, where it was like, hey man, I don't need
his white mouth.
Yeah. All right. So what are the chances? I hate to ask that question this early, but the reason why I asked that is because I just read an article and it got me to thinking. So the headline is Derek Chauvin's, this MSNBC 2 hours ago, Derek Chauvin's trial is a chance for the justice system to prove it can actually work.
Work in what way though?
Yeah,
right?
That's what I'm saying. Like,
that's the justice system working, right? Such a nebulous headline because anybody can take it and it can mean anything to either side. right? Because an acquittal could mean the justice system is working for those people, and a conviction means the justice system is working. So that headline is,
But it also implies that it's not working. So, when you say something is proof that it can finally work, then it
right,
must
right,
mean
right.
it wasn't working before. But y'all
True.
didn't admit to that before
Right. No.
when we said that.
Right. 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 Absolutely. Absolutely.
But what are the chances? We've seen cases with video. We've seen I could name at least 10 where the video is compelling enough to maybe not prove the case or prove premeditation, but at least the video is, I saw this happen. Eric Garner, Rodney King, Philando Castile. Yeah, y'all beat it, but it doesn't take away from the fact that I can see this happening on video. What are the chances this time that it's like, all right, y'all effed up, just guilty? Because 9 minutes of this. I mean, come on, guy. Like, what are the chances of the case going that way?
So any trial is 50-50. Any trial, because the 2020 video is not the only video that the jury is going to consider. So last Friday, the court, on defense motion, agreed to allow the defense to enter evidence of the 2019 arrest, in which George Floyd displayed some of the same behavior, in which he was taken to the hospital because he had ingested some of the same drugs, methamphetamines, fentanyl, and he was experiencing high blood pressure, and he was on the verge of a stroke, according to those medical records, right? And so they want to bring that in to show that this is his modus operandi. When he's getting arrested, this is what he does. He goes into this behavior, and then he ingests drugs, because in the 2019 arrest, he was taken to the hospital. He wasn't taken to jail, right? And so this is the thing that he's developed. So if I just act a little like I can't really understand what they're doing, and then I ingest some drugs and I get to the hospital, then I won't be charged with a crime. And so the defense is saying this is what he does. And he tried to do the same thing in 2020. It's exactly the same. And so he didn't die as a result of Derek Chauvin. He died because he didn't get the medical treatment that he got in 2019, when he was on the verge of a stroke or a heart attack. And so the defense is saying causation is an issue here. It's not the fact that Chauvin was on his neck. It's the fact that he was full of opioids. He had compromised health issues. He had some COVID issues, and the culmination of all of those things is what caused his death, not Chauvin. And you only need one person to believe that. You only need one person.
But
you have to have all of them for a conviction or all of them for an acquittal.
Okay,
so
now
one person will say, and that is a hung jury. A hung jury for the defense. I'm a criminal defense attorney. That's a win.
Yeah.
Why? Because we get to go home. And y'all got to do it again. And y'all got to think about doing it again.
The way you laid it out, now I got the answer to my question. He'll get off, because I didn't even think of that. And I've known, I come from a certain era, and I remember cats who used to do that.
Yes, me too.
They'd take off running and swallow it.
And swallow.
Yeah. And so now that I didn't know that that's what he did, and I didn't know that he was arrested for that previously.
Yeah. Videos coming in of that.
Oh, jeez.
Video and DNA evidence, because I believe what they're showing from 2020 was that there was pills in the back of the car where he was with in the Chauvin arrest. Right. So they're linking this up to say this is exactly the same. And look what happened.
Pattern. This is what he does.
Modus operandi, the exact language they use, the MO. That's what MO stands for. Modus operandi. This is his method of operation.
That being said, you just gave us how the defense would try it. Give us the other side. How, if you were a prosecutor, how would you try it?
He didn't die in 2019, but did you die? Right. So I'm right away. I'm going to say, yeah, these events are exactly the same, but for the fact that Derek Chauvin put his knee on my client's neck, or on George Floyd's neck, for 8 minutes and 46 seconds. But for that fact, he would still be alive, just like he was alive in 2019. So even when you get bad evidence, because you always get bad evidence as an attorney, you have to know how to use it in your favor. And so the prosecution has been trying very diligently to keep this evidence out. But now that it's in, I really hope they know how to use it. right? And what they need to do is exploit the fact that Chauvin wasn't around in 19 and George Floyd lived.
Mm.
And all things being equal, the only difference now is 8 minutes and 46 seconds of your knee on his neck. And that's why he's dead. You have to be able to prove causation. You
Yeah.
have to prove every element of every crime, right? You have to prove that he intended when it comes to the second degree. That's they charged him with causing with assault that resulted in a death. So you have to prove that he intended to assault George Floyd. I don't think they're going to get that. I don't think they're going to get that. Their best shot is the reinstated third degree. Their best shot, and that's the depraved mind,
Okay.
right? The depraved mind, which is the same count that Muhammad Noor was convicted of. If you recall, he was the Minnesota police officer who was convicted of third-degree murder for killing Justine, I think it's Dumond, something like that. He got 12 and a half years on third-degree conviction, and that was recently upheld.
And so they recently reinstated the third degree on this charge, correct?
Reinstated, exactly.
Because
the judge threw it out initially.
But so the hope would be, or the implication would be, that they think that they would be better off getting that third than the second.
Yes. Or they hope the jury will compromise, which is not uncommon, right? So if you have 3 charges and the jury is like, well, not really that, not really, but we got to give them something. All right, give them the third. Give him not guilty on the second counts, and then give him guilty on the third. That's a good compromise.
Now, with the Muhammad Noor case that you brought up, that 12 years he got from the judge.
Yes.
So in this case, even if he's found guilty on third degree, it's up to the judge to either nail him to the wall or babyfoot him.
That's right.
So he could.
The range on third degree, based on what I've been reading, is 10 to 15 years. That's the range. But precedent is precedent, and they are very keenly aware that the Muhammad Noor case is lurking in the shadows. And so you really can't treat a police officer who's convicted of the exact same crime that much differently. So he should get at least 12 and a half or more. He should, if he gets convicted of third degree.
Well, the argument would be Justine Dumond wasn't hopped up on methamphetamines. That's what they're going to end the comparison.
It's not a mitigating circumstance for the crime. It's still you're convicted of third degree murder. It's the same exact charge.
Okay. So you're saying if guilty, and there's already been a precedent, that's what should happen. That's
what did happen so far, right? And so we want to keep that consistency. What happened with the third degree is when it got tossed, the prosecutor said, reconsider, judge. Judge said, no, I'm not going to reconsider. I'm going to keep it tossed. They appealed to the intermediate level court in Minnesota. And that court was just hearing Noor's appeal. And so when they came down and said third degree can apply to one person, that was the issue. So let me be clear. Typically, third degree murder is when you create a risk to others, right? And so the judge says this didn't involve others. This only involved what is alleged a risk to one person. That's why it doesn't apply here. That's why he threw it out. However, the high court said, with respect to Noor, third degree can apply. Others can be one. They upheld that others being one with respect to Justine Drummond. So if it could be one for her, it could be one for him.
Right.
Right. And so that's why he had to then follow the court's decision, because the precedent came directly from the court above him. So he had no choice but to reinstate the third. So the precedent is there, and he's acutely aware of it, and he knows what Noor got, and he knows the court upheld that. So I really can't see in good conscience him, if he is found guilty of the third, getting less than that 12 and a half.
Now, are you familiar with the team that's doing the prosecuting?
I am not. And I've only been able to see, one or two of them. It's hard to. This is my issue. 95% of prosecutors are white people, or white women, men and women, and they can't tell our story. They can't tell the George Floyd story. So what the prosecutor tried to do was, they had a motion to admit a psychiatrist or a psychologist who was going to explain why George Floyd responded to the police in the way he did, right? The trauma that he has experienced in his life, having been a gunshot victim in the past. When he sees a gun, he freaks out, it's PTSD, blah, blah, blah. The judge's like, no.
Yeah, that don't work for us. They don't believe we feel pain and we get
No,
scared.
none of that.
Yeah, we
Right,
don't
none
get
of that.
scared.
And
Yeah.
so that can't be conveyed now because white prosecutors, and I hate to say it, you can't convey my pain.
Yeah.
You just cannot. And which is why you needed somebody to come in and do it for you. And now the judge has shut that door. So how are you going to rebut and explain his behavior in that video, in the 2019 video?
So the reason why I asked that is because I can remember when the Chauvin, the George Zimmerman case, and I remember that was my first real case in a long time that I had paid attention to, probably since maybe the OJ or whatever, where I was like day one, I was in it and watching court TV all hours of the day, and I was just so disappointed because I ain't go to liquor law school, but I watched a lot of Law and Order, and I was like, these guys are really like they're throwing this game. I'm watching the TV like you are just giving it away. So I wonder, somebody in your position, do you look when you see the press conferences and when you see who's lined up to do the work? Do you look at it and be like, they could have got somebody better than that?
Yes, I absolutely do.
Yeah.
And I do it, having been a former prosecutor and as criminal defense attorney, I do it on both sides.
Yeah,
I'm like, if I was on this case, somebody going to jail. And if I was on this case, somebody walking out with me. Like,
right.
That's just how I feel about it. You know? Because I can look at the evidence and you have to know how to make something of it. It has to mean something. You are an interpreter in that court. You are translating for that jury what this evidence means. It's not just evidence. It means something. And you have to tell them how to look at it. This is how you should consider this evidence. And I don't know that they have that. I don't see it in there. But listen, it hasn't started yet.
Yeah, right.
And I'll say to everybody in the chat, if you had to vote right now, how would you find Derek Chauvin?
Yeah, let's see real quick. Let's say thumbs up is not guilty and thumbs down is guilty in the YouTube chat. Let's do a quick straw poll.
Yes.
She's about to make a point. She's gonna make a point. So thumbs up if you think Chauvin will be found not guilty. If the trial started today.
If you were a juror today.
If you were a juror today.
You have to vote right now. What is your vote?
Yeah, it's gonna be a little bit of a delay.
Everyone should have the same vote.
No, everybody should. Yeah, right.
Everyone should have the same vote.
If you the juror,
that's not the vote, right? Yeah. I'm looking at nope.
Of course, Jay Lee says not guilty.
And that's why I brought that up, right? Everybody's saying guilty.
Right.
He's presumed innocent. You haven't heard any evidence. You haven't heard one piece of evidence. Has it? Because the trial hasn't started. You haven't heard any evidence that could convince you of his guilt beyond a reasonable doubt. Remember, the jurors can only consider the evidence that comes in that trial, not the news reports, not the shit on social media.
So everybody in this chat would be struck down as potential jurors because we're not fair. We're not impartial at all.
Exactly. And that's what I want. I want to rehab all of you because I want you to be jurors someday. Right. And so one of the things that I do is when I'm doing voir dire or voir dire, and that's the questioning of prospective jurors, the first two questions I ask, the first one is, when you walked in here, how many people said to yourself, I wonder what he did? Right? Because most people, when you walk in, you see the guy sitting next to, and you're like, I wonder what the fuck he did.
Yeah.
So my next question is, now, how many people said, I wonder what he's accused of? Yeah, you see that? And that's the reaction I'm looking for every prospective juror at that moment. Because it's in that moment that you got to check yourself. And
so which one would you get rid of them? You said you wanted to rehab them. Like what would you?
Well, first, I want people to be aware of their thinking. Right? Because just like you said that, right. People may not even be aware that they have already presumed someone guilty.
But white people do that all the time. White people do that all the time.
Right, but not when you walk into this courtroom. You got to be different. We in a vacuum. This courtroom is not real life. Okay, we're gonna ask you to do some shit you do not do. Right? In real life, we're gonna ask you to make a decision for which you don't know the consequences. You have to decide guilt or innocence, and we're not going to tell you how much time this person is going to get as a result of that. People don't make decisions like that.
No.
Right? No. That's not how you go about your life. You're like, okay, if I decide this, what's going to happen? All right. And then you weigh That's not what happens in court. You don't get to make the sentence. The judge is going to tell you. You don't get to consider the sentencing. Okay, you don't get to consider that. Neither do you get to use sympathy or bias or any of those things that we typically use. You can't use any of that when you are deciding this case, right? And so all of these constraints come about that, those of us who are not in the courtroom, right? When the decision comes, we're like, how the fuck they got, what did they
Yeah.
and it's crazy, but the truth is because they're not exposed to what everyone else is exposed to, and they have a limited set of facts that they must consider, and they can't go outside those facts if they're doing their job as they swear to do it.
Right.
Yeah. So very easily, when we put aside our expectations, we can see that this man can very, very well, very likely be acquitted on all counts.
Now, this isn't a capital murder case, but in a capital murder case, it's the same process. You don't weigh in the fact that this person might get the death penalty. You don't.
So understand that capital murder cases have multiple phases, right? So it's always a bifurcated trial in a capital murder case. First, you have to decide the guilt or innocence of the person, and then they have a separate phase to determine whether or not the person should be put to death.
Okay.
Yeah, so it's sort of separated out so that you don't conflate the two. One is the guilt. Two is, okay, should he be put to death, or should he be, get life in prison without parole or something to that effect.
I don't care if it is a closet. You still looking mad efficient.